Good morning, class. Today, I'll deal with the topic law of confessions, which is another very important area in the law of evidence. The term confessions is not defined anywhere in the Evidence Act, neither there is any specific provision that deals with the relevancy and the admissibility of confessions. It is only admitted in the form of an admission, which is defined in section 17, read with section 18 and section 21 of the Indian Evidence Act. However, there are certain provisions which talk about the circumstances in which a confession given by the accused person and the confession given by the co-accused in a joint trial may be admitted by the court. If we look into the scheme of the provisions that are laid down in the Evidence Act, section 24 to section 30 deal with the deal with those circumstances wherein confessions may be made admissible. While in these provisions, the first three provisions, section 24, section 25, and section 26, they talk about involuntary confessions which are barred and cannot be proved in the court of law. Like section 24 provides that any confession that is an extracted one cannot be proved in the court of law. Likewise, section 25, which prohibits any confession which is made to a police officer from being proved in the court of law. Also, section 26 mentions that a confession which is made in the custody of a police officer cannot be proved in the court of law. So these are presumed to be involuntary confessions and they are barred from being proved in the court of law. Whereas section 27 and section 28 lists down certain exceptions wherein a confession may be proved in the court of law. Like section 27 says, wherein a statement leads to the discovery of a, a certain fact, even though that statement is recorded in police custody. So that much of the statement that has led to the discovery of a new fact may be proved in the court of law. Section 28 mentions circumstances wherein an involuntary confession may also be proved, like wherein the law says that wherein the impression that is caused by inducement, threat, or promise is said to have been removed, then such confessions become admissible. For the same reason, Section 164 of CRPC mentions that the court has to ensure before recording confession that the accused person has no is not acting under any kind of inducement, threat, or promise. And if there are any such likelihood, the confession may not be recorded, or the court may give cooling off period to the accused person so as to ensure that the any probable inducement, threat, or promise may be may be removed from the from the mind of the confessor. Likewise, section 29 and section 30 talks about the admissibility of confessions under certain circumstances. Moving further, as I mentioned that the confession is not defined in the Evidence Act in any of the provisions. However, Sir James Stephen attempted to define confession in the terms of admission as defined in section 17. In his book on law of evidence, Stephen mentions or defines confession as an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed the crime. If you look into the highlighted portion of this definition, at any time, stating and suggesting the inference, while interpreting the term at any time by a person charged, it it should not be interpreted to mean any time even before the commission of the crime. Otherwise, if we give this broad interpretation or this broad meaning to the term at any time, it will only denote an intention to commit crime. So at any time refers only to the time after the crime was committed. In this definition, Stephen would have uh, meant it in this way only, that any time includes the time that starts after the commission of crime, and then only a person can admit or confess that yes, he has committed a crime. And by the term after the crime was committed, I mean to say that the time before or during investigation or trial. Now, if we try to understand the term stating or suggesting the inference that he committed the crime, we can understand it by two illustrations. If, let's say, an accused person says that he stabbed and killed Mr. B, a person A says that he stabbed and killed Mr. B. In this statement, he is clearly accepting that he has committed the crime and he has killed Mr. B by stabbing him. This is a simple, a clear acceptance and admission of the crime committed by the accused person. Whereas if we look into the term suggesting the inference that he committed the crime, and let's take the illustration that the accused person says that he bore ill will towards B, he went to his house with a knife with an intention to kill him. If you recollect the classroom discussion that we had, here this person is talking about the circumstances. He is not accepting that he killed Mr. B. He is not accepting in clear terms that he killed Mr. B. He is accepting the circumstances that has the tendency to incriminate him. But it is also possible that someone else might have killed him, right? So, but considering the definition that confession is an admission made at any time by a person with a crime, stating or suggesting the inference that he committed the crime, herein suggesting the inference that he committed the crime, wherein he says that he bore ill will towards B, went to his house with a knife with an intention to kill him. He is just accepting the circumstances which might suggest an inference that he has committed the crime. While in both these circumstances, as per Stephen's definition, both amount to a confession. But the high courts in India were divided on this view. Regarding the first statement or the first illustration, wherein the accused says that he stabbed and killed B, the high courts were sure, the courts in India were sure that this amounts to a confession, as there is no doubt, as the person clearly accepts that he has killed Mr. B. While the confusion was, the courts were divided with respect to the second illustration, wherein a person makes a statement which suggests an inference, or wherein a person accepts the circumstances which points towards the guilt. This confusion was settled by the Privy Council in the Pakla Narayan Swamy versus Emperor in 1939. In the judgment, Privy Council listed down a test to be followed before qualifying a statement as a confession. The court says, and I read, a confession must either admit in terms the offense or at any rate substantially all the facts which constitute the offense. This implies, firstly, a confession must admit in clear terms that yes, he committed the offense. And second, if there is no clear acceptance of the fact that the accused has committed the crime, the accused accepts all the facts which constitute the offense. That means the statements or the admissions which are made by the accused should be such that they are self inculpatory, that they have the tendency to incriminate. The statement may not be clear acceptance of the guilt, but the statement accepts all the facts which constitute the offense, so that it is sure that this person who is making an admission is the one to be charged with the commission of the offense. And since then, the courts in India have followed it and implemented it in various decisions, like this Palvinder Kaur versus State of Punjab, Agnu Nagesh versus State of Bihar, Nishikant Jha versus State of Bihar, Behra Tanti versus State of Orissa, and Sahu versus State of UP. This is just a small list of leading judgments that I have mentioned here, but there's a huge list of judgments which have followed the trend that has been set by the Paklanarayan Swamy judgment. Thus, we can say that admissions are a species of statements which suggests an inference as to fact in issue or relevant fact, while confessions are a subspecies of admissions made by the accused person wherein he admits his guilt in clear terms or accepts all the facts which constitute the offense, so as to be distinct from admissions in certain aspect. So before I conclude, there are few points to be noted down. One is confession is not defined in the Evidence Act. Confession needs to be a voluntary admission of guilt or statements which suggest the commission of the crime. Thirdly, intention to communicate is not necessary, as it was held in Sahu versus State of UP, wherein a person, after killing his daughter-in-law, muttering to himself that he has finished his daughter-in-law once and for all, and someone overhears it, it it amounted to a confession, though extrajudicial in nature. And lastly, a confession may be judicial confession or an extrajudicial confession. Judicial confessions, as you all know, are those confessions which are made to judges, while extrajudicial confessions are any other confessions made to any person other than a judge. That's all for today. We'll be dealing with the provisions from section 24 to section 30 in the next video. Thank you.